The respondents urge the court in deciding on the possible reliefs to take into consideration public interest and apply appropriate balance to avoid an eventuality that would create chaos and disruptions in the entire criminal justice system. Article 23, sub-article 3 of the Constitution specifies that the reliefs that this court may grant in constitutional petitions, but proceeds to discretionarily give the court the power to consider appropriate reliefs by stating as follows. In any proceedings brought under Article 22, a court may grant appropriate relief, including, and that is it. The use of the word appropriate relief and including makes the list non-exhaustive and empowers the court to consider what in its view is the appropriate relief, meaning that the court may not be restricted to the list provided in the Constitution or what is pleaded by the parties. It can, in appropriate cases, decide on the relief that suits the circumstances of the case. In Law and 2 others versus Maora Maternity Nursing Home and 3 others, the court affirmed this approach by holding thus, and I quote, as in the case of constitutional petitions, there are areas of available remedies. What a court endeavors to do upon confirming of any infringement is to grant an appropriate remedy. Even in instances where a party fails to ask for a specific relief, a court, depending on the nature of the matter, ought to craft an appropriate relief. End of quote. In the circumstances of this case, I'm of the view that there is need to consider an appropriate proportion, to consider appropriate proportionate remedies that would bring to an end the continuing violation by the respondents while guarding against abrupt, wholesome, destructive disruption that crashes the criminal justice system in a manner that is detrimental to the interests of the public and the administration of justice generally, thereby avoiding erosion of public confidence and ensuring that the rights of the victims of offenses are also taken into consideration. Considering that the respondents acknowledge that they have now taken steps towards satisfying the legislative interventions necessary to remedy the ambiguities that led to the said provisions being declared unconstitutional, this court is of the humble view that judicial supervision through structural interdict order would be appropriate. It is to be noted that the Kahiga case did not have the framework of a structural interdict order. In making this order, I'm guided by the ones of the Constitutional Court of South Africa in the case of Black Church Trust versus Minister of Social Development and others, where, in justifying its decision to issue structural interdict order, cited the following ones of Mogoweng, Chief Justice in Horope case as follows. It bears emphasis that this is an exceptional case that cries out for an exceptional solution or remedy to avoid a constitutional crisis which could have grave consequences. It is about the upper guardian of our Constitution responding to its core mandate by preserving the integrity of our constitutional democracy. And that explains the unique or extraordinary remedy we have crafted. End of quote. The Supreme Court in multiple case versus Kenya Airports Authority was emphatic that structural integrity can rightly issue under Article 23. The court, I have cited that case, I will not go through it. So despite the violations, this court finds that an immediate order that stops all prosecutions for robbery with violence, and attempted robbery with violence would create an unprecedented turmoil and confusion that would cause much harm and uncertainty. Hence, more specific, realistic measures and a judicial supervision would eventually remedy the harm without igniting an explosive impairment of the entire criminal justice system. Judicially supervised interventions or structural interdicts will, in my view, provide a more efficacious remedy of addressing this lingering problem within realistic timeframes. And I am guided in that regard by the case of Republic vs. Council for Legal Education, where the judge explored the issue of a structural interdict. This court is satisfied that the petitioners have established the continuing violation of their rights by the respondents. However, this court has a duty to weigh the vindication of individual rights vis-a-vis the disproportionate harm that granting of such orders may cause to the public and the interests of justice as a whole. In my humble view, issuing blanket order prohibiting all trials, issuing a blanket order, just a minute, that immediately prohibits all trials for robbery with violence, or ordering the release of all persons undergoing those trials, or prohibition of any specific arraignment with immediate effect, would be inimical to the overriding interest of justice that transcends the interests of the parties in a constitutional petition. While this court duly acknowledges there has been non-compliance with Kahiga judgment, and thus the state is guilty of continuing violations, this court opines that the specific orders sought by the petitioners are not in themselves the appropriate remedy, and thus would exercise its discretion to fashion what in its view are appropriate reliefs. The orders that commend themselves for issuance in this petition are thus as follows. 1. A declaration that since the 15th of March 2018, the respondents continue to violate Articles 2, Sub-Article 2 and 4, 3, 20, Sub-Article 1, 21, Sub-Article 1, 23, Sub-Article 3 of the Constitution through arresting, charging, detaining, trying, and or convicting people under Sections 295, 296.1, 296.2, 297.1, and 297.2 of the Penal Code, as these provisions were declared unconstitutional in Kahiga decision due to their ambiguity in definition of the offenses, thus violating Article 52B of the Constitution. B. A declaration that since 15th of March 2018, the respondents have violated the fundamental rights and freedoms of all individuals arrested, charged, arraigned, detained, held in custody, tried, convicted, or sentenced under Section 295, 296.1, 296.2, 297.1, 297.2, including rights guaranteed under Articles 27, 28, 29, 48, 52B, and N of the Constitution. In the interest of administration of justice and to safeguard public interest by avoiding a legal vacuum in the respect of grave criminal offenses and to facilitate orderly legislative intervention towards correcting the defects that led to the declaration of unconstitutionality of impugned provisions of the Penal Code, the operation and the effect of the orders specified in A and B above are hereby suspended until 30th June 2027 to allow for the judicial supervised interventions that will ensure compliance. D. For the next 18 months, the Attorney General, the Director of Public Prosecutions, and the Parliament shall be required to file an affidavit in this court every 6 months, commencing on 30th of June 2026 and thereafter on or before 30th of every 6th month and ending on 30th of June 2027, detailing the specific legislative, administrative, or policy measures taken towards addressing the ambiguities in law that occasioned the declaration of unconstitutionality of Sections 295, 296, 297 of the Penal Code, and update on parliamentary processes involved, including the timelines thereof. Upon expiry of the 18-month suspension of declaration of invalidity, commencing 30th June, commencing midnight, just a minute. Upon expiry of the 18-month suspension of the declaration of invalidity, commencing midnight of 30th of June 2027, A, or number 1, Roman 1, the declaration of invalidity in respect of Section 295, 296.1, 297.1 and 2 of the Penal Code in the current form shall take effect forthwith. B. Any charges, prosecutions, or proceedings based on the aforesaid provisions of the Penal Code in the form declared unconstitutional shall stand quashed as of midnight, 30th of June, 2027. Any pending charges, prosecution or proceedings based on the aforesaid, any pending or fresh. Any pending or fresh charges any pending or fresh charges, I'm trying to frame it as I read. Any pending or fresh charges, prosecutions, or proceedings based on the aforesaid provisions of the Penal Code in the form declared unconstitutional shall on midnight of June 2027, midnight of 30th June 2027, stand quashed for unconstitutionality, and any affected persons be set free forthwith, unless where continuation of such charges, prosecution, or trial is justified under any other valid law. Each party shall bear its own costs. So that marks the end of the judgment.